Over the past few weeks, a lot of people across the tech sector, startup community, and immigrant workforce have been quietly asking the same question. What happens when a state decides it has had enough of what it believes are abuses inside the legal immigration system and steps in with its own investigation? That question is now front and center after it's confirmed to have launched a formal investigation into alleged H-1B visa fraud, a move that could ripple far beyond state borders and affect companies, workers, and families who thought they were safely inside the system. In this video, let's understand the latest updates and its implications. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. The H-1B visa has always been one of the most talked about and misunderstood employment visas in the United States. For many highly skilled workers, it represents opportunity, stability, and a possible path toward a green card. For employers, it is a way to fill specialized roles when qualified U.S. workers are difficult to find. But for years, critics have argued that the system is vulnerable to abuse, manipulation, and outright fraud. Now, Texas is signaling that it believes some of those concerns rise to the level of state-level enforcement action. According to officials, the investigation is focused on whether certain companies and intermediaries may have misrepresented job roles, wages, or work arrangements connected to H-1B petitions. While immigration enforcement is typically a federal matter handled by agencies like U.S. Citizenship and Immigration Services, states can become involved when allegations intersect with labor laws, consumer protection statutes, or business fraud regulations. That is the legal doorway Texas appears to be walking through. At the center of this effort is the Office of the Texas Attorney General, which has broad authority to investigate deceptive business practices and violations of state law. Officials have not publicly named specific companies at this stage, but they have made it clear that the inquiry is active and ongoing. Subpoenas, document requests, and interviews are reportedly part of the process, signaling that this is not a symbolic announcement, but a real enforcement action. For H-1B workers already in the United States, this news has understandably triggered anxiety. Many people hear the word investigation and immediately worry about deportation, visa revocation, or sudden job loss. It is important to be clear here, this investigation is not aimed at individual visa holders simply for being on H-1B status. Instead, it is focused on alleged misconduct by employers or third-party staffing firms. However, when companies come under scrutiny, workers can still feel the impact through layoffs, contract terminations, or sudden changes in employment arrangements. One of the core issues investigators are reportedly examining is whether some employers listed full-time specialty occupation jobs on paper while placing workers in short-term, lower-skill, or bench status roles. In reality, another area of concern involves wage levels. The H-1B program requires employers to pay at least the prevailing wage for the position and location. If a company claims a high-skill role but pays far below market rates, that discrepancy can raise red flags not just for federal agencies, but also for state labor authorities. This matters because the H-1B system already operates under intense scrutiny. Each year, demand far exceeds supply, leading to a lottery system that leaves many qualified applicants without visas. When allegations of fraud surface, they fuel political arguments that the program is broken or unfair. That in turn can influence future policy decisions, processing timelines, and even the tone of enforcement under administration, shaped by figures like Trump and the broader Trump administration, which previously emphasized aggressive oversight of employment-based visas. From a legal standpoint, Texas's move raises a bigger question about how state and federal roles intersect in immigration-related enforcement. Immigration status itself remains a federal matter, but employment practices, wage compliance, and business representations often fall squarely within state jurisdiction. If Texas uncovers evidence of systematic misrepresentation or labor violations, It could refer findings to federal agencies, triggering audits or enforcement actions by USCIS or even the Department of Labor for companies operating in Texas, especially those heavily reliant on H-1B talent. This investigation is a warning shot. It suggests that compliance cannot be treated as a paperwork exercise. Job descriptions must match reality. Wage levels must be defensible. Work site arrangements, including remote placements and third-party client sites, must be properly disclosed. In the current environment, within any gap between what is filed and what actually happens on the ground can become a liability. The timing of this investigation is also notable. Many H-1B workers are already navigating long green card processing timelines, waiting years for priority dates to become current in the visa bulletin. For them, job stability is not just about income, but about maintaining lawful status, while cases move slowly through USCE and later the NVC and consulates abroad. A sudden employer-side investigation can throw those carefully planned timelines into chaos. At the same time, Texas officials argue that their actions are about protecting workers and the integrity of the labor market. From that perspective, cracking down on fraudulent practices is framed as a way to ensure fair wages, honest competition, and lawful business conduct. Whether one agrees with that framing or not, the practical reality is that enforcement attention tends to create a chilling effect across entire industries, not just among those accused of wrongdoing. For H-1B workers watching this unfold, the most important thing right now is not panic, but awareness. Know your job description, understand your wage level. Keep copies of your offer letter, pay stubs, and work assignments. If your role or location changes significantly, that may require an amended petition. These are not new rules, but moments like this investigation highlight why they matter so much. It is also worth noting that investigations like this often take months, sometimes years, to fully resolve. Early headlines can sound dramatic, but the legal process is slow and methodical. Allegations must be proven. Companies have the right to respond. Findings may lead to settlements, fines, compliance agreements, or referrals to federal agencies. Rarely does everything happen overnight, even if the fear feels immediate. Looking ahead, this case could influence how other states think about their role in employment-based immigration oversight. If Texas proceeds aggressively and sees political or legal success, it may embolden similar actions elsewhere that could create a patchwork environment where companies face not just federal scrutiny, but state-level investigations tied to labor and business laws. For policymakers, this moment adds fuel to the broader debate about reforming the H-1B program itself. Supporters argue for higher wage floors, stricter oversight, and better enforcement to weed out bad actors. Critics warn that excessive crackdowns risk driving talent away and harming innovation. Caught in the middle are the workers, many of whom followed the rules in good faith and now worry about consequences beyond their control. As this investigation develops, we will be watching closely for concrete outcomes. Will specific companies be named? Will penalties be imposed? Will federal agencies take follow-up action? And perhaps most importantly, will this lead to real structural changes in how H-1B cases are reviewed, approved, and monitored? For now, what is clear is that the immigration landscape remains unsettled. Enforcement priorities shift, political pressures rise, processing timelines stretch, and actions taken in one state can send shockwaves through the national system. If you are an H-1B worker, an employer, or a family waiting on a green card, staying informed is no longer optional. It is essential. That's all we have for this bulletin. The U.S. Immigration Hub channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Immigration Hub channel. Thank you for watching, and we'll see you in the